Good evening, everyone. Thank you. I'd like to call this Supervisor special meeting to order. And just to be clear, it is a meeting of the supervisors, and we are here to hear from Dr. Chandler. The Planning Commission is invited, but it is not a meeting for them. So if everyone will stand, we'll pledge allegiance in a moment of silence. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Moment of silence. Thank you. Next on the agenda is the adoption of the agenda. Entertain a motion.
I'd make a motion that we adopt the agenda. I did want to say something about, it's really wonderful to see such a robust turnout tonight. And ordinarily, we would welcome a public comment period. With this being a special work session, and I know we have quite a bit to cover this evening and have Dr. Chandler joining us. I think we're all here for informative purposes or informational purposes. And I just wanted to make that clear that that's the nature of this meeting, and that's why this agenda does not include a public comment period. That it's targeted specifically for background information and education for the board. Thank you.
I'll second.
All right, Ms. Smith, Mr. Whitson, any further discussion? All those in favor say aye.
Aye.
Aye. Any opposed? All right. So we are, I think, very lucky to have Dr. Chandler on Zoom with us. So far, I think I've been on 4 of the supervisor courses with Mr. Whitson and one with Ms. Smith. And Dr. Chandler teaches all of those, and I am just amazed at his wealth of knowledge with regard to any county in the Commonwealth of Virginia. Dr. Chandler, if you'd like to take it from there.
Well, thank you, Madam Chair. I see the agenda. I don't see faces, and it's not critical that I see faces, but what are you all seeing me, or how's this thing working? I'm sorry.
No. So, Mr. Chandler, we are not seeing you. I will put up various documents as you refer to them. Wonderful. And share them back to you on your screen as well as to the people in the audience.
Excellent. That is wonderful. Well, again, thank you very much for the kind invitation to be with you all today, and I look forward to interacting with you as you consider the fundamental issues attendant to the function of planning and zoning in the Commonwealth of Virginia. My background, I was a faculty member at Virginia Tech for nearly 30 years, have served as a community planner for 4+ years. I was a member of the Planning Commission in Blacksburg for 3 years, 2 years as chair, and a town council member for nearly 20 years in Blacksburg from 1984 to 2003. While on faculty at Virginia Tech and in partnership with the Virginia Department of Housing and Community Development and the Citizens Planning Education Association in Virginia, we developed the Virginia Certified Planning Commissioner Program. Some of you as members of the board, I think, are familiar with that. And if memory serves, Mr. Frazier, as a board member, completed that course some time ago. It has been offered now in excess of 100 times. I'm no longer affiliated with it. Having retired from Virginia Tech, we did transition the program to VCU, and they are now managing and running and administering the program. I think all is going well in that regard, and I would strongly recommend the program for any citizen who's interested in learning more about planning, land use, and zoning practices in Virginia. specifically and in America in a more general sense. It's open to anyone who would like to enroll in the course. You don't have to be a planning commissioner or an elected official. The program began in 1985 and as indicated, continues to the present time. Part of what I'm going to be sharing with you today is borrowed from that particular course. I know that Mr. Curry has put on the screen the Albemarle County Land Use Law Handbook. That is a reference and resource that we will be using this evening. That is a marvelous publication. Greg Campner, who serves as county attorney in Albemarle County and has been with that county for nearly 20 plus years now, probably 23 years, and county attorney for at least 3, if not 4 years. I've lost a little bit of track of time due to some health issues that has sidelined me for the better part of the last 3 years, but trying to slowly get back into some mode of operating efficiency with respect to these various topics. In advance of looking at the Albemarle County Handbook, which is available on the Albemarle County website, it's a rather extensive document, 300 plus pages in length. Greg is updating it as we speak, and the 2021 edition will be forthcoming in about 3 weeks. Greg uses it in the certification exam preparation course that we do for the Virginia Association of Zoning Officials. Greg has also been an instructor in our certification programs for planning commissioners, BZA members, and the Virginia Certified County Supervisors program that VACO and Virginia Tech co-sponsor. As far as the background, I've been privileged to work in every county, every city, and just about every town of this Commonwealth in the last 45 years, having worked in this field. And hopefully that insight and experience has provided me with some insight relative to the application of planning and zoning practices in the Commonwealth. We'll actually begin this evening's session looking at the materials that I shared with Gary and board members, which is the Legal Foundations of Planning and Zoning. This is material that Sharon Pandak, an attorney with Grehan, Taves, and Pandak and Stoner. Stoner has gone back to public sector work in Fairfax County. And so it's now Taves, Grehan, Randy Grehan, who used to be with Fairfax County, and Taves with, I believe, also Fairfax. And then Sharon was nearly 30 years in her tenure with Prince William County, serving as Prince William County attorney for the better part of that tenure. Sharon, much like Greg Campner, along with other attorneys, some of you may be familiar with the name John Foote. John Foote was a county attorney in Prince William, and he's been in private practice with Walsh, Colucci, and others out of Washington, D.C. He's in the Manassas office. John has represented public sector clients as well as private sector clients. He is just a walking encyclopedia relative to knowledge of zoning in Virginia and zoning law as promulgated by the courts. I've been privileged to be an expert witness for John in several instances. He's an outstanding attorney and an excellent resource attorney, and is still quite volunteers his time in support of good planning and zoning practices. Although he is now in the private sector, he has not lost his communitarian principle or sense of purpose. Thus, he has been free in providing advice and technical assistance without charge in those instances where the client or customer is not in a position to be able to compensate at the corporate rate. We have benefited in our certification programs with experts like Foote, like Sharon, like Greg Campner. Also, we've in recent time have utilized the services of a former county attorney in Roanoke County, who happens to also be a member of the Board of Supervisors in Roanoke County, recently elected to that position, and will make reference to some of the materials that Paul Mahoney has shared with planning commissioners and elected officials across the state over the past, since 1985. So part of what I'm bringing to you this evening will borrow from the experts that we have been able to bring to fore in support of the certification training for planning commissioners, BZA members, county supervisors, as well as municipal city and town council members. Sharon is an outstanding attorney and an excellent resource as well. In fact, their firm works almost exclusively within the public arena. And she functions as a retainer attorney for several jurisdictions, as well as the several authorities, including the Airport Authority in Washington, D.C. and Dulles. So there's some great resources. Feel free to contact any of the individuals that are referenced in the materials that we'll be utilizing. And these are materials that they have developed, and they're fully aware that I'm utilizing the materials. All of this is in the public domain, so it's not necessarily carries with it a copyright prohibition. Thus, the availability of the land use law handbook from Albemarle County to anyone in the Commonwealth of Virginia. So I want to begin again thanking Debbie for the welcome, and I will, in concert with the county administrator, will proceed through the material that is been shared with you. We'll stay in session until about 6:45, and then maybe take a 15-20 minute break if that's acceptable. Reconvene at or 6:50 and reconvene at 7:10, and then stay in session until about 8:15, 8:20, and then see where we are. I believe the agreed to time was roughly 5:30 to 8:30, so we'll honor that ending time, and then follow up with you if there is a desire, a future session or one-on-one through some correspondence electronically or otherwise. Before we delve into Sharon's handout, I always appreciate her art as well as the props that she utilizes. And you're seeing here the construction process. Now, this is not the construction of a no-growth wall. Some people look at this and say, oh, these are the communistic planners are saying nobody else is coming into our community. That's not the metaphor or the message. The message here is that planning and zoning is a building block exercise. Planning and zoning is premised on a solid foundation, and that foundation is linked back explicitly to the United States Constitution as well as the Commonwealth of Virginia Constitution. The second page is the actual introduction that Sharon reviews, and we'll touch on that. But in advance of beginning with that legal regulatory framework, which is essential to the practice of planning and zoning, I'd like to begin by asking you all to give thought to from whence from where did planning and zoning come from? How long has it been around? Any sense or any idea? I know it's a very general kind of question, but there is some history associated with planning and zoning. Maybe not necessarily in the light that you might think of history with a direct link per se, because zoning is fundamentally a 19th century innovation. And it's only been in America since the 1916 in the 20th century. So we're just a bit more than 105 years experience with zoning and by extension, planning in America. But the roots go way, way back in time. Some of the history that you may or may not be aware of. One of the initial reference points that I like to share and involves the Hammurabi Code. Some of you might be familiar with that terminology. Some of you may even be familiar with the contents of the Hammurabi Code, which were precepts or principles of both government administration, but also the law or rules by which society would function. This is back in the Babylonian Empire and the time of Nebuchadnezzar, however you choose to pronounce his rather lengthy name. But if you pull up the Hammurabi Code and do an internet search, you'll find something popping on the screen that will make reference to the code as being a template for how that society and people internal to that society were going to cooperate, collaborate, and operate within a safe environment, if you will. Some of the precursor for what you and I refer to today as the police power provision has its deep roots all the way back to the Hammurabi Code. It featured about 237 different precepts or standards. And again, if you review them, 20 or 30 of them jump right out at you or me, and you would say, that sounds like a zoning statute or a subdivision or building code statute. Probably the most famous precept or standard in the Hammurabi Code was the notion of an eye for an eye or a tooth for a tooth. I suppose that means if do something and I cause you to lose an eye, then you have the right to cause me to lose an eye. Along that line, some of the building standards that were present in the Hammurabi Code. If I were to retain someone to put an addition on my adobe living in ancient Babylon, and said addition were to collapse, then I had the right to go to the contractor who built or made the addition and cause a portion of his house to fall upon him. Some suggest that the quality of building back in those days was pretty superior. In fact, a lot of evidence has been discovered archaeologically. Other precepts that stand out from the code ultimately gave rise to what you and I today would refer to as building codes, subdivision standards or regulations, and the forerunner or precursor to modern day zoning. If you fast forward from the Hammurabi Code to the 12 Tables of Rome during the time of the Caesars and specifically starting following the shift by Julius Caesar away from the Republic to the dictator / emperor, some of the initial line of Caesars were very community oriented, and they developed standards that the Romans utilized, much like the Babylonians, in constructing then modern day Rome. Rome, back in the time of the Caesars, exceeded 1 million people, first community known to humankind to have that kind of population, and wasn't replicated until we got into the 20th century. So it was quite the place, as we probably all recognize if we've had the benefit of seeing it with our own eyes or reading about it or seeing pictures in history books. The 12 Tables of Rome were a building code / subdivision / zoning code requiring or mandating certain types of construction, the materials that would go into constructing an improvement, be it a house, be it a public facility, be it a community use. the first recognized Western European shopping center, outdoor shopping center, was built during the time of Vespucian, mispronouncing his name, as during his reign as an emperor, and before Nero as an emperor. And that particular shopping center was on some of the hills, the 7 hills of Rome, and it had hours of operation. It had hours in terms of when the products and commodities could be delivered to the shopping center and the patrons and operators. There were a number of different standards that were governed or developed and governed in the development of the road system to and throughout Rome. The 12 tables also showed deference for important natural elements in the environment. In fact, if your property was blessed with a olive tree, and the olive tree exceeded a certain diameter or caliper in terms of its diameter or its height, then you could build, but you had to not encroach upon the olive tree. There were defined separations, much as we associate with zoning, of one property from another property. The olive tree was favored in part because it was a source, a chief source of income for Romans, and as well as a source of light and a food source. So it was a prized commodity, and thus it was protected by a building code and building statutes. If you go from Rome to jump way forward to the time of the Magna Carta in early 1200s in Great Britain or England, some of the protocol that we utilize today in terms of our statutes, our constitutions, were first captured in narrative and embraced by King John. The law of the Indies was a contribution made by the Spanish, and King Philip in Spain, of course, was one of the great colonizing powers in Europe, back and forth between Great Britain, France, the Netherlands, but Spain and Great Britain for much of the time in the age of exploration. The Spanish and the Portuguese were out and about before the English. And the law of the Indies was a zoning and land development standard that applied in Spain at the time, but then when properties were settled in the New World, St. Augustine, for example, we credit Jamestown as the oldest permanent English settlement, which it is, Jamestown, Virginia, but St. Augustine was founded earlier and is the oldest community in America. And of course, it was founded by the Spanish. And St. Augustine was a planned community. It was laid out in advance. The Spanish viceroys, which were a form of administrative staff representing the interests of the king, also had the authority to and obligation to develop a plan for the settlement. And that was evidenced in the law of the Indies that was used not only in St. Augustine, but used by the Spanish in Mexico and in Southwestern America, modern day America. Albuquerque, Old Town Albuquerque, for example, Tucson, Arizona, some of the California communities in Southern California, all of those were planned in advance. And it was a rather exacting proposition. The individual charged with that obligation walked the territory, laid out the metes and bounds, and then designed what the community would represent or look like, and what would be featured internal to the community. Spanish with the presence of the faith. Obviously, as you're probably familiar, churches were quite common, so that was present. Markets were, mercado or centers were also present in that development plan. And that individual had to get on the slow boat back to Spain and carry his plan to the king for his approval. And so then he would have to get on the ship and go back. So it was a multi-month process, a year or more process before a plan put to paper could actually be implemented. It all had to be signed off by the powers that be back in Spain. That standard carried forth and was mimicked by the English. Jamestown is planned community. Jamestown, the initial Palisades and then the initial settlement that took hold in 1610 or 1607, but then formally took hold in 1610, benefited from a plan of development, which was authorized by the corporation that underwrote the founding of Jamestown. And of course, the colony, the attempt was to give the English a foothold, fearing that the Spanish may come back. The Spanish settled along the Chesapeake area, York River, and the Rappahannock River as early as 1580, but those settlements did not prosper and they vanished. So the English settlement at Jamestown is the first permanent settlement. And like all settlements thereafter, they were all planned. In fact, today, if you go to Williamsburg, municipal building, there is outside the entrance to the municipal building the Wren plan for Colonial Williamsburg, outlining not only did he design the administration building or the first academic building at William and Mary, which is the second oldest college in our nation, he also was authorized and charged with developing the land use plan or the layout of then Colonial Williamsburg. And it's kind of remarkable to look at that plan. In fact, that's what Rockefeller and others used when they chose to give rebirth to Williamsburg in terms of what we see and appreciate today in Colonial Williamsburg. So the roots of planning are again extensive. They've been around for a long, long time. Also central to it, this conversation of planning and zoning are sort of competing political theories. Some of you have probably recognized the name Thomas Hobbes, and some of you might well also recognize the name of John Locke. Hobbes and the competing political theories were fundamentally concerned themselves with the rights of the individual versus the protection of the state, the community, or nation. Hobbes viewed people in a somewhat negative light or manner. In fact, his narrative, his writings suggest he uses words like people are nasty, they are brutish, and they are greedy. Thus, order is needed in a society, and government should provide that order. Hobbes maintained that people would willingly cede certain rights in exchange for security, stability, and order. And that view was viewed in a positive way by the Scots, some of the English, and by other entities on the continent in Europe. John Locke viewed people in a more positive light, suggesting that the right of the individual is supreme, and he believed that government is legitimate if we must have it. If we must have government, it is only legitimate. It's legitimate only if it receives the consent of the governed through a social contract, which in turn protects the natural rights of life, articulates, and then suggests that the natural rights of life, liberty, and property are to be sustained. Locke authored the English Bill of Rights, which, as you're probably aware, influenced considerably Thomas Jefferson, George Wythe, and George Mason. And those gentlemen were borrowed heavily from Locke's English Bill of Rights in drafting and developing the Virginia Bill of Rights, as well as the Declaration of Independence for the nation, and then subsequently some of the narrative that we associate with the U.S. Constitution. Jefferson was a Lockean believer in that he thought government should be limited, and it should favor the right of the individual, the rights of individuals against the power of government. Famously, Jefferson said, "The best government, the government that governs best is the government that governs the least." Alexander Hamilton, a compatriot of Jefferson during that founding era, along with John Marshall, who was a cousin of Jefferson and became famous in his role as the Chief Justice of the United States Supreme Court for 34 years. They viewed the system of government in a more Hobbesian manner or way. They viewed or felt that government needed to play a role at both the federal level, ultimately then the state and local level, and that a centralization of some of the governmental functions would be necessary to protect the public health, safety, and welfare of the people, which that very terminology, the protecting the public health, safety, and welfare, is the essence of a term that we sometimes use in this conversation about planning and zoning the police power. It's clearly limited or utilized in that context when you think about whether you view government as limited or expansive. Government is expansive in the Hobbesian or in the Alexander Hamilton view, a strong central government, or that was really when the Articles of Confederation were revised and replaced with the Constitution. The Hamiltonian view, the one out. The Jeffersonian view that we would have limited government, limited, little to no central government, and that responsibility would be the function of the individual in a spread out sort of fashion across the land. Judge or Justice Blackstone in the English courts defined a nuisance, which is linked to the police power provision and linked to comprehensive or planning and zoning as applied in America, defined a nuisance as anything that unlawfully worketh, hurt, inconvenience, or damage. And that is a component that's important in that the courts early on in the 19th century and in the 20th century made the correlation or connected what we today call planning and zoning as a subset of the nuisance theory or application of the nuisance theory. Zoning, as we know it today, is a 19th century innovation. In fact, Otto von Bismarck, upon unifying Germany in 1870, 1871, mandated that communities of a particular size, population size in Germany, in the unified Germany, must develop what he called zoning plans. So he's the first person to use the term zoning. We don't find the term anywhere in recorded history until it's enunciated by Bismarck. And he viewed the zoning plan as a way to preclude the presence of nuisance in communities. And he also thought that the zoning plan would balance the right of the individual property owner with the rights of his or her neighbors and the community itself. This became an important component in jurisprudence in our nation, commencing in the 20th century. Zoning was first articulated and first applied in the 1870s in Germany, and then spread to Belgium, spread all across Europe, including Great Britain. But it didn't come across the pond to our nation until 1916. 1916 is when New York City developed and adopted an ordinance that they labeled zoning ordinance. And it was immediately challenged in the courts, and the New York Court of Appeals sustained the zoning ordinance as a proper expression of the police power protecting and providing for the public health, safety, and welfare, and that by segregating uses by type and then by density, it would establish a standard that would assure for that public health, safety, welfare. The New York Court of Appeals in 1920 upheld the zoning ordinance for New York City. The appeal to the Supreme Court did not occur, U.S. Supreme Court. As such, many communities in New York and then subsequently in other parts of America began adopting zoning plans. Something that's still utilized in that particular state. The U.S. Supreme Court in 1926 resolved the constitutional doubts concerning zoning in its 1926 ruling involving the village of Euclid, Ohio versus Ambler Realty. And there's some references in Sharon's material to Euclid v. Ambler, as well as in Greg's land use law handbook for Albemarle County. We'll look at that, but before we do so, I want to just share a couple of quick thoughts, if I may, relative to the particulars of that case. Euclid is a village in Ohio. It's today a modern-day suburb of Cleveland, Ohio, and it was along the northern tier by Lake Erie. And in adopting zoning, the village of Euclid identified, if memory serves, 6 districts and excluded businesses and industries from the residential districts. Ambler Realty had acquired, prior to the adoption of zoning, or while it was being considered, acquired 68 acres adjacent to an industrial area that was being utilized for industrial purposes. And once zoning was adopted by the village alderman, the Amber Realty Company sued, claiming that zoning was unconstitutional, was an unconstitutional application of the police power. And that, and they also indicated and stated that if zoning was not found to be unconstitutional, they had some good lawyers, they should still be compensated. In addition to their claiming that it was unconstitutional, they also claimed that it was a taking because they had paid considerable sum of money for the 68 acres that they purchased with the goal of developing it in an industrial manner or way. Unfortunately for them, the Euclid, Ohio zoning ordinance zoned their property residential. The records show that some of the acreage that they purchased, some of it cost as much as $20,000 an acre. The zoning ordinance violated the federal constitutional guarantees of due process and equal protection of the law as applied by the 14th Amendment through the 5th Amendment, or extending the 5th Amendment through the 14th Amendment. The U.S. Supreme Court held that the regulation involved, meaning the zoning ordinance in Euclid, was justified because the ordinance was exercised as an aspect, using Justice Sutherland's words, aspect of the police power asserted for the public welfare, as found in the U.S. Constitution preamble. So in making an argument that sustained the zoning function as being representative of the police power and the authority to provide for the general welfare, in order, the preamble to the U.S. Constitution was actually cited by the United States Supreme Court, in part because the attorneys representing Euclid, Ohio, argued that the basis for zoning in America was provision for the public health, safety, and welfare, which is a fundamental reason we have local governments and state governments, and even arguably the federal government. Thus, the idea that promoting the general welfare was ordained and established by the U.S. Constitution. That's pretty strong language that Justice Sutherland articulated in writing the majority opinion for stating that zoning was constitutionally permissible. The Virginia Constitution, Article 1, Section 3, has similar language. If you look at our 1970 Constitution, government is or ought to be instituted for the common benefit, protection, and security of the common benefit, or for the common benefit of the community. And the best government is one that is capable of producing the greatest happiness and safety, and is most effectually secured against the danger of maladministration. Now, that narrative is a little complicated in part, but it is a premise that was introduced in the Virginia Constitution as early as 1902, and then subsequently refined and utilized in subsequent constitutional revisions up to and including 1970. The U.S. Supreme Court, going back to Euclid, said that before a ordinance can be declared unconstitutional. And this is very important because this standard is still with us today. That's such provisions must be clearly arbitrary and unreasonable, serving or having no substantial relationship to the public health, safety, morals, or general welfare. And that was a rule or a standard, a bar that the Supreme Court of America established in determining whether or not a zoning regulation or zoning ordinance would rise to the level of satisfying for that requirement. And the validity of the ordinance depended on two competing considerations. And in the ruling for Euclid, the first, the impact on constitutionality, constitutionally protected private rights was first, and then second, unreasonable deprivation, if you will, of due process and the arbitrary denial of equal protection and the impact on the general welfare of the community. So, validity, in the view of the court, is judicially diminished by balancing these conflicting considerations. In the words of Justice Sutherland, again from Euclid, he stated it is inevitable, inevitably imprecise for the majority or identifying where a line is drawn in terms of how the legislation, distinguishing a legitimate legislative action or regulation from an illegitimate assumption of power. You can't do that with precise definition. Thus, if validity of the legislative classification for, in this instance, zoning, is fairly debatable, then the legislative judgment, in this instance, that meant the Board of Aldermen, City Council for Euclid, Board of Supervisors for Rappahannock County, the legislative judgment must be allowed to control. So that established the fairly debatable standard, which is still governs today in substantive due process violations or cases involving zoning and planning in not only America, but also Virginia. The Euclid ruling approved nuisance theory as the conceptual underpinning of zoning in America. Thus, a use must be considered in conjunction.
The Zoom connection.
A right thing is in the wrong place. And where he famously said, like a pig in a parlor instead of the barnyard. The idea being that there's a right place for certain things and a wrong place for certain things. And it's at the discretion of the local legislative body to determine where is the right place for certain kinds of land uses and intensity of land uses and where they would be inappropriate in terms of location. The Euclid v. Ambler case, very quickly, is essential to our understanding of planning and zoning in America and in Virginia. We mimicked the Euclid v. Ambler ruling in Virginia with the Goree versus Fox building code and subdivision regulation case from Roanoke in 1927. Actually, no, excuse me, 1926. In fact, it was roughly couple of months after the Euclid v. Ambler ruling from the U.S. Supreme Court that the Virginia Supreme Court found action taken by the city of Roanoke to be constitutionally expressed application of the public health, safety, welfare doctrine vis-a-vis the police power. So that particular orientation has been, again, mimicked across much of the nation. 2 years after the Euclid v. Ambler Realty case, the U.S. Supreme Court heard another land use case involving Cambridge, Massachusetts, and a gentleman by the name of Nectow. And in that case, the U.S. Supreme Court made clear that when zoning makes no sense on its face, an ordinance then will be judged to be void, will have no standing, and will have no legality attached thereto. What happened in that instance, Cambridge, much like other communities, was developing its initial zoning ordinance, and Nectow had an industrial property next to a vacant parcel, and the vacant parcel was bounded by residential and open space uses. And Nectow concluded that it would be best to designate that vacant parcel next to Nectow as a residential use. And Nectow objected to that, stating that his current use, industrial use, was one that would not be a good neighbor adjacent to a residentially zoned property. And he appealed all the way to the United States Supreme Court, arguing that the zoning designation on its face made no sense. It wasn't rational. It wasn't an extension of the provision of the providing for the public health, safety, welfare. And the U.S. Supreme Court sided with Nectow, and they remanded the issue back to Cambridge for resolution. And thus the court indicated that if zoning, again, on its face is not reasonable, then it will not be judged as being legitimate, and it'll be suspended in terms of its application. With that, I'd want to take a look at the material starting with Sharon's handout. And we look at this here because it goes into more exacting detail relative to key components that you're probably already familiar with when you think about planning and zoning in Virginia. If you look at the material that's on the screen or that you have in front of you, you see that it begins with the Code of the Commonwealth, Chapter 22, Title 15.2. And the very first component that is of critical importance is the Declaration of Legislative Intent. Article 1, General Provisions, contains a declaration of the General Assembly's intent for why it's encouraging its localities to plan. This particular section of the code, 15.2.2200, was added by the Virginia General Assembly to the Virginia Code in 1924 and 1926. And it borrowed heavily from the Standard Enabling Act for Planning and Zoning that one Herbert Hoover, as Secretary of State in New York State, developed. In fact, Hoover drafted the enabling statutes that the General Assembly of New York added to the New York Code that permitted New York City to draft the nation's initial zoning ordinance. And the state enabling acts, both for planning and zoning, that Hoover promulgated during his tenure as Secretary of State in New York State, were adopted by Virginia and most other states word for word in the 1920s through the late 1930s. Thus, some of the narrative that you see in Sharon's material is verbiage that is taken directly from the statement of intent as drafted by Hoover, who was an engineer by training. The narrative that you see there can be broken down into individual components, if you will, and you'll see that elsewhere in Greg's material, wherein it talks about that the purpose of planning is to encourage localities to improve the public health, safety, convenience, and welfare of its citizens, and to plan for the future development of the community to the end that transportation systems are carefully planned, that the needs of community facilities are articulated, adequate highway, utility, health, education, recreation facilities, a whole laundry list of things that were identified as being the reason for why the Commonwealth was encouraging its local governments to plan are captured herein. Now, some of the items that you see in this Declaration of Legislative Intent were not present, were not drafted by Herbert Hoover. The necessity of identifying the concerns of military installations be recognized and taken into account in considering future development in areas immediately adjacent to military installations, for example. And where practical, the installation commanders shall be consulted by the Planning Commission. For example, in Norfolk, with the Naval Air Station, the Naval Base, there's ongoing dialogue between the Norfolk City Planning Commission, Norfolk City Council, and the commanding officers for the respective bases. In order to accommodate the needs of the military installation and make for a good neighbor with the military installation. Elsewhere, towards the end of that declaration of legislative intent, the very bottom line and a half, it says that the growth of the community be consonant with the efficient and economical use of public funds. That last line and a half has been the basis for the transformation of the Supreme Court rulings in Virginia beginning in 1980 with the Lerner case from a neighbor to your north, Loudoun County. And that particular component of the Declaration of Legislative Intent has been in the 40 plus years since that ruling, sustained in succeeding land use cases. And this introduces for Virginia an element known as the timing of when development will occur or can occur. Looking at the balance of 15.2.2200, Article 2 describes the Planning Commission. Article 3 reviews the comprehensive plan. Article 4, the official map. 5, the capital improvement program. 6, subdivision and development. Article 7, zoning. Article 7.1, TDRs, transfer development rights. Article 8, road impact fees. Article 9, impact fees. These are the fundamental foundations for the practice of planning and zoning in Virginia. If you in Rappahannock County, both as a commission and as a governing body, are guided by the content of the respective articles, then you have afforded yourself not only a substantial foundation upon which to build a comprehensive plan, subdivision ordinance, zoning ordinance, capital improvement program, and related applications, but you've also built a solid defense that will withstand judicial review if the question before the court involves a substantive due process consideration. Influencing all of this as well is the scope of local authority, the interpretation and deference. As you all know, we're a Dillon Rule state. And we're one of there's 36 Dillon Rule states out of the 50 in America. Not all of them are strict constructionist states like we are. We are a strict constructionist Dillon Rule state, along with about 4 other states in our country. The majority of the 36 states that operate under the Dillon Rule actually are like North Carolina, which is Dillon Rule, but they've also adopted a home rule provision. Thus, they're a hybrid state with respect to interpreting the judicial reach or judicial efficacy of the action. John Forrest Dillon was a justice on the Iowa Supreme Court, and he wrote a treatise on municipal powers, authorities, duties of municipalities. He also, in serving as a justice in the 1860s, 1870s, was witness to what some argue was probably the most corrupt era in local government in America. Tammany Hall, Boss Tweed, come to mind in the 1860s, 1870s. And as a result, Justice Dillon, somewhat Hobbesian view of local government. He thought that they were corrupt. He thought that they were managed improperly. He thought that only the worst of people put themselves in the limelight or in the public, engaged in public service. In articulating his standard that became known as the Dillon Rule, he observed that not the best and brightest were attracted to government service. As a result, local government cannot be trusted, and local government should be restricted and should be statutorily governed or governed statutorily in terms of what it can do, can't do. Thus, he articulated what became known as Dillon's Rule, and it has three parts, fundamentally four parts. First, you can only do those things that are expressly authorized, express powers. In other words, they're in black and white. Rappahannock County must appoint a planning commission. That's an expressed authority. It's something you must do. In addition to having the right to exercise an expressed or power, you also, as a local government under the Dillon Rule, are entitled to engaging in a power that is implied through the express power. That sounds logical and reasonable, but in terms of land use planning and zoning in Virginia and the Virginia Supreme Court, our court has not been very liberal in that regard. Our court is more comfortable in stating that the best authority for a local government to engage in a practice is found in the express provision of said practice. So you have the expressed power, implied power, and then the third component of Dillon's Rule, he said that a municipality can do those things that have been declared essential to the needs of the corporation. That usually comes in the form of a charter that's granted or given to a city or town upon its creation, which happens in Virginia. And then the fourth rule or component of Dillon's Rule said that whenever there was a question as to whether or not said power exists for a locality to engage in a practice, if there's any question as to whether or not the power is present or not, then the court shall resolve the issue against the locality. Thus, Dillon Rule, the takeaway for us, you can do those things that are expressly authorized through expressed power. Dillon's Rule took hold across much of America from the 1870s up until the 1920s. It's still active in America today, as evidenced by 36 out of the 50 states operating under Dillon's Rule or a hybrid Dillon Rule home rule. Home rule is associated with Justice Cooley operating in Minnesota courts, and he advanced a construct that is a little bit different from the Dillon view of local government. He stated that when an authority is associated with a governmental function that on its face clearly is in support of the public health, safety, welfare doctrine vis-a-vis the police power, then a locality should be authorized to engage in that practice. They don't need anybody's special permission, in other words. The case before Justice Cooley involved, if memory serves, I believe it was trash collection or some service involving sanitation. And the applicant or the individual involved already had the authority to engage in that practice, but wanted to extend that practice beyond the initial standard that was applicable at the time under the Dillon construct. So Justice Cooley abandoned Dillon in favor of what he articulated became known as home rule. And that is that you, as a local government, have certain rights, privileges, and responsibilities that are self-evident. And that as long as they're not violative of the state or federal constitution, then a local government can engage in that practice. Maryland to our north is a home rule state. Now that doesn't mean you can do whatever you want in Baltimore, Maryland, because the same theory articulated in Dillon applies even in a home rule state. In a home rule state like Maryland, if you pick up the Baltimore, Maryland Code, it reads in a fashion a little bit different compared to the Virginia Code. Virginia Code tells you what you can do. The Maryland Code tells you what you can't do. You can do whatever you wish in Baltimore in planning and zoning, except for the listed prohibitions that are featured either in the Charter for Baltimore and or the Maryland statutes. So even in a home rule state, Mr. Dillon still has some authority, if you will. The narrative that Sharon provides you provides reference to some of the Supreme Court cases that have applied the Dillon construct or Dillon provision. Yes, go ahead. Comment?
I think somebody was just coughing.
Okay.
Just letting you know, Dr. Chandler, we're at 6:37.
Okay. All right. Thank you. We'll actually go on till about 6:50. My intent is to try to get through the bulk of Sharon's material. And then we'll make our transition to Greg's material and the other set of materials that Gary shared with you all that we utilize in the Planning Commissioner program involving decision-making and deliberation. The cases that are referenced here, you are also going to see in Greg's material. Some of them are very, I think, straightforward because they show you what the issue was in the estimation of the Virginia Supreme Court. All of these are Virginia Supreme Court rulings. And we'll refer to some of them as we look at some of the case law more specifically with Greg's material. The presumption of validity for legislative actions on page 4. Historically, as you see, it says the Supreme Court has given great deference to local land use decisions based on foregoing enabling authority in the Virginia Code. This is true, and there is a great deal of importance associated with the presumption of legislative validity. And that means your zoning ordinance in Rappahannock County, your subdivision ordinance, your comprehensive plan. If you perchance have to go and defend any of those documents in circuit court, the presumption of the court is that those documents on their face were properly construed, constructed, and developed. They're fully within the context of the prevailing constitutional standards in Virginia and the Code of the Commonwealth. The burden is on me bringing the complaint that you have acted arbitrarily or capriciously. The substantive question relative to the efficacy of your planning and zoning ordinance, if they're crafted within the context of 15-2200 and 15-2-2223, which describes in great detail the purpose of a comprehensive plan and the studies and surveys that must be featured in developing said comprehensive plan, and overlay that with the purposes of zoning in Virginia, 2280 and 2283 and 2284. I know there's a lot of numbers, but go back to Sharon's cover page, the building of the blocks or the stone wall, if you will. They're all built on top of each other. So you begin with 2200, the Declaration of Legislative Intent. Some communities actually utilize some of that narrative that you see in 15-2200 as the preamble for their local comprehensive plan. There's nothing wrong with that. And in fact, it's actually a prudent and wise thing to do, as they've done in Albemarle County, because if you have to go to court to defend your county comprehensive plan, you're making an immediate reference back as being constitutionally permissible. You're showing immediate linkage back to an action of the General Assembly in 1926 and added to in subsequent years up to and including 1962 and 1978, et cetera, et cetera. They're in the footnotes for that particular section of the code. And if you then, on top of that, develop your comprehensive plan reflective of the requirements of the Virginia Code under 15-2-2223, and then you do the same with your zoning ordinance under 15.2-2280, and then purposes of zoning 2283, and then the criteria to be considered when drawing and applying zoning districts under 2284. If you link those 5 sections of the code with one another, then you have crafted an ironclad defense that will be difficult for any petitioner to secure compliance or secure the action of the court favoring their point of view, suggesting that substantively your plan, your zoning ordinance, your subdivision are constitutionally incompatible or imprecise. Now, under procedural due process, page 4 in Sharon's material, the Supreme Court decisions have struck down local land use decisions that have been plagued by what we would call procedural defects. In fact, the court at any level, circuit or supreme, has zero tolerance for a local government that screws up when, from a procedural perspective. You can't adopt a plan, amend a plan, adopt zoning, amend zoning without required public hearings. Proper notification, the ability of the public to be heard. If you advertise for a public hearing and it's off by one day in terms of advertisement in a newspaper of local circulation or distribution, then the court has no recourse but to, if you are sued for not meeting the requirements of the Virginia Code, I think memory serves, has to be advertised twice within 14 days. And if you miss that by a day, probably no one in your community knows that potentially, but you know that you have missed it. As a result, you probably ought to back away rather than take action, because as we've seen in the Gas Mart as well as the Glazebrook cases, Virginia Supreme Court, there's no tolerance for failing to satisfy for the procedural requirements. So local government, if you are accused of violating the procedural guarantees of due process and proper advertisement, et cetera, that's a burden. That's a mountain you're not going to be able to successfully climb. And it's better to go back to start over and do it right so that you're not guilty of a procedural due process violation. The limitations, constitutional limitations in the Virginia Code. You do have some reference here in terms of the relationship between the constitutional protections for individuals, their property, and the government's exercise of its police power through enactment of the zoning ordinance. Again, all of that is what you see there is a direct byproduct of the Euclid v. Ambler ruling, and then as articulated in the Goree Fox Virginia Supreme Court case a few months later. Maybe let's see, Gary, if you want to back it up just a little bit, go back to, yeah, right there. Let's come down looking at the screen here. You see the reference to the Brooks, the West Brothers Brick versus Alexandria in 1937. Again, the police power provision being articulated. This statutory scheme must be viewed in the framework of both the U.S. and Virginia constitutions regarding the power of a government over its citizens. And the limitations that stand out are compensation, for example. You can acquire property. You can't take property without just compensation. That's the federal as well as state constitutional reference. Property may be regulated pursuant to the police power, but if we go too far in the Mahone case from Pennsylvania Coal Company, then compensation may be required. Being charged with a taking and then proving that a taking has occurred is a difficult threshold to satisfy in Virginia today. There are some cases, as Sharon notes here, from South Carolina that stand out. But in the main, the taking, the idea that a taking is compensable is applied generally through the zoning practice is a misnomer. In fact, the very practice of zoning is a taking. If you don't have zoning, and there's some states, some counties in Virginia that do not have zoning as we speak. The only regulatory authority they utilize is state health department and their subdivision ordinance. But the zoning ordinance, but they don't regulate land use in a sense that zoning regulates land use. If you have zoning, and as you do in Rappahannock County, it is a line drawing exercise, as both the U.S. and state Supreme Court have articulated. And it is at the discretion of the local legislature, County Board of Supervisors, to draw said lines. Where is it going to be residential? Where is it going to be commercial, industrial, whatever uses you have in your zoning ordinance? It's at your discretion to determine the metes and bounds of those uses. And that act in and of itself constitutes a principle of taking. And that's why early on in the history of zoning, many of the cases at the local level, meaning state level or state Supreme Court, argued that zoning was a taking and that you should be compensated because land was taken. The Euclid case, that taking principle was articulated by Ambler Realty Company, and saying that their investment in that 68 acres was quite substantial, which it was. I forget the aggregate number, but it was a big number. And they said that if you're going to now say, after spending that level of money, I want to say it was $750,000 to $1 million, now we get to build houses. We're not going to get a return on our investment. As a result, the village of Euclid should compensate us for the amount of money we paid to acquire the property and the gain that we would have enjoyed until they came along with this silly rule. Supreme Court said, this U.S. Supreme Court said, you're not entitled to any compensation whatsoever because the land ultimately zoned for residential use is a reasonable, legitimate use. Whether or not you get a return on your investment is a byproduct of the risk-based capitalist society we live in, 1920s as well as the present day. As long as there's a residual use that on its face is reasonable, The charge that a taking has occurred and the party involved is entitled to compensation is going nowhere in the Virginia court system. Due process under the 5th and 14th Amendments, due process, the right to hearing, speedy trial, all of those sorts of things with the 5th Amendment. The provisions of the 5th Amendment were extended to the states with the adoption of the 14th Amendment following the American Civil War. So sometimes when you look at cases, you'll hear the complaint, the filing will say of the violation of the 5th and 14th Amendments. That's just a way of acknowledging the power of the 5th Amendment as foundational, and then by extension through the 14th Amendment, all of the guarantees of the 5th are now extended to the states and the people through the 14th Amendment. It's a tad bit redundant, but it's powerful in terms of the court proceeding. And it reminds the court that the court needs to be aware and reviewing the complaint has indeed the guarantees of the 5th and 14th been extended. Substantive due process requires that there be a valid purpose, and the means adopted to achieve the purpose must be substantially related to it. There is a reference to Kelo, which, as Sharon correctly points out, would not have occurred in Virginia. And actually the ruling that the Supreme Court articulated in the Kelo decision mimics what the Virginia courts have said over the many years since the Virginia Supreme Court has been ruling in this arena. The regulations can be arbitrary or will be struck down as arbitrary and capricious, as essentially finding a violation of the substantive due process clause. So point being, if you can hang your hat on some substantively articulated regulation or standard, in other words, we're doing this, we're zoning this land this way, or we're articulating this as our desired land use for this section of Rappahannock County because it is the best way to satisfy for the legislative intent of 15-2200. We've studied it under the studies and required surveys of 15-2223. And now we are recommending a certain type of zoning which satisfies for the 11 articulated purposes of zoning under 15-2283. Showing that linking pin function, linking those 4 segments of the code together in that fashion, and weaving that narrative and presenting it in your comprehensive plan and your zoning ordinance will provide you with a fail-safe security with respect to any substantive due process challenge. Thus, most local governments have been, in the last 40 plus years, there's the claim of substantive due process of law violation has not been supported by the court system. Because the locality is able to show how they have linked 2200 to 2223 to 2283, 2284. You have narrative in your revised comprehensive plan, and Rappahannock County does an excellent job in that regard. And so that provides you with a very solid foundation for the substantive clarity of your adopted comprehensive plan in Rappahannock County. Again, procedurally, if we mess up, then we have no recourse but to do it over again. Either we'll do it ourselves or we'll have the court tell us to go back and do it again. Sometimes people take a community to court thinking that if the court rules in their favor, then they get to do what they want to do. No, what happens is the court will remand an issue back to the county and suggest to the county that they revisit it and this time do it correctly. A court, through its ruling, cannot in effect change the underlying zoning of a county parcel of land or territory. So sometimes people go to court under the mistaken notion that if they win in court, they'll get what they want. And that's not the case at all. continuing through Sharon's material, you go a little further down, you see reference again to some of the key cases. The Williams case being key, but also you see reference to the 1983 provision of the 1964 Civil Rights Act. We do have to be aware of that, that property rights are protected by the statutes, and localities can be held liable when they violate the constitutional rights of citizens that might be before you. So there may be a developer in your community that comes forth, and you might think, and maybe the community at large views that developer as a real black hat kind of character, not any good and doesn't do good work. Well, you can't use that as a reason why you would turn down his application. He is entitled to a fair hearing. He's entitled to an objective hearing. He's entitled to fairness on your part, and you can't make statements that he may in turn be able to claim is a violation of his civil rights guarantees under that 1983 provision of the Civil Rights Act. And you get in trouble very quickly, and your jurisdiction is not going to be able to get you out of that said trouble. So you have to witness prudence whenever you're in the public forum. Be careful of what you say and how you say things. Continuing on down through her material, the exhaustion of her administrative remedies is required before a landowner can attack the constitutionality of an ordinance. The comprehensive plan, very quickly, is a guide for decision making. It's required by the Virginia statutes that was added to the General Assembly of 1975, requiring that every county, city, and town by July 1, 1980 must have prepared and adopted a comprehensive plan. That same legislation in 1975 mandated the appointment of planning commissions at the county, city, town level. You already had a planning commission in Rappahannock County. Some jurisdictions, they did not have a planning commission, so they, by benefit of that mandate, were required to appoint a planning commission. All counties, cities, and towns, all counties and cities have planning commissions today. Most towns have planning commissions. Some towns do not have a planning commission because they contract with the county to serve as their planning commission. Washington, your only incorporated town, has its own planning commission, as you're aware. And you can collaborate with another planning commission if you so choose. Some jurisdictions, they might pick it up and flip through it and say, it looks good to me. They might say, well, we haven't had much change in the last 5 years, so we're going to affirm that it continues to resonate and have value for our community. Thus, we'll continue with it. In a more technically correct world, you should, in sticking with the plan without modification, re-advertise it, share it with the public, hold a public hearing so that you then can put a new date on it. Rather than having a plan that says 1990, adopted 1990, and here it is 2021, so it's been 30 years, so it hasn't been reviewed in 30 years. One might attack that plan as not being relevant and applicable to the conditions at present, even though the community hasn't changed that much. So if the 5-year review, it ought to be formalized, is what I'm suggesting to you. Defensible, effective, comprehensive plan. There are a number of things that we'll look at, not only in Sharon's material, but also Greg's material that are foundational to articulating a defense or rationale for why the plan is reasonable and defensible and appropriate for the jurisdiction. If you continue on down, you move on to the public facility component, the mandatory review relative to 2223, and then you get into zoning. If you drop back to the zoning, look at the standard of review for right here. Yeah. Legislative decisions, again, that presumption of validity is critical. The fairly debatable standard is also critical. Both of those, again, their roots extend back to Euclid v. Ambler and Gorey versus Fox. We'll talk about the Lerner case following the break. That is a case wherein the fairly debatable standard was sustained, but it also introduced for the first time Lerner v. Loudon, the timing of when a development or rezoning should occur or development should occur. And that's a very critical case that was first advanced in Ramapo versus New York back in 1972. The constitutionality of growth management was fashioned and supported by the appeals court, federal appeals court, and the United States Supreme Court refused to consider cases that objected to that. The Lerner case is the first case in Virginia that utilized the principle of timing and phasing of growth in relation to infrastructure. And that case is foundational for utilizing that approach to community planning and zoning to this day. If you continue on down, Gary, with this material here, amendments to the zoning ordinance, we'll spend time with Greg's material because he covers the same territory. 15.2.2283 outlined the 11 purposes of zoning. 15.2.2284 of the Virginia Code outlines the 11 criteria that are to be considered in drafting and or applying a zoning ordinance. So if you're drafting a zoning ordinance for the first time, or maybe you're reviewing and updating your zoning ordinance, those 9 criteria in 15.2.2284 ought to be front and center in developing or revising your zoning ordinance. Now, in applying the zoning ordinance, it's very important to recognize the value of that narrative. Applying a zoning ordinance means you're considering a rezoning. So those 9 criteria that are listed under N15-2284 are the very basis upon which you will say, yes, we'll support this proposed rezoning, or no, we will not support the proposed rezoning. We'll look at that in greater detail following the break. Gary, if you go down a little further here, I'm trying to remember what's in here. Okay, the proper process, conditional zoning. You operate conditional zoning. There are 3 types of conditional zoning in Virginia. There's the conditional zoning as first promulgated in 1973 by the General Assembly of Virginia, authorizing conditional zoning and the acceptance of proffers, including cash. It applied to Fairfax County, Prince William County, Loudoun County, and jurisdictions that were shared a common border with Fairfax County, and the 2 counties east of the Chesapeake Bay, which are Accomack and Northampton County. And that was Senator Fears, longtime member of the Virginia Senate from the Eastern Shore. But in developing conditional zoning initially in 1973, the Commonwealth identified just those few localities that would be given the green light to practice conditional zoning. In part, it was adopted in response to the needs of Northern Virginia, Fairfax County specifically, growth was running away, and there was the inability of the county to keep up with the rapidity with which growth was occurring. And so they were looking at ways to either not approve growth rezonings or be able to condition rezonings. Thus, in partnership with Northern Virginia Home Builders Association and others, Till Hazel being a key player therein, it was settled that Virginia would adopt conditional zoning, which again authorized the acceptance of proffers, which were voluntary concessions made by an applicant, which have the force of law upon adoption. We still have the proffer or conditional zoning in Virginia. The traditional or original conditional zoning is still at play in Fairfax, Loudoun, Prince William, and the two counties of the Eastern Shore when conditional zoning was generalized so the balance of Virginia could practice it. In 1980, I want to say 83, 88, something of that narrative. I can't remember right off. The goodies were taken away. When conditional zoning was granted to the balance of Virginia, the acceptance of cash was not extended. And there was some concern and consternation expressed. So in 1998, something that attorneys refer to as new old conditional zoning was adopted. And that's an amalgamation of the new and the traditional conditional zoning. If you've experienced high growth or you're adjacent to a community that has experienced high growth, and now that high growth has actually been reduced down to, I believe it's 10% growth on decennial census basis, then you can practice the new old conditional zoning, which carries with it the ability to accept property as a proffer. The proffer process has worked relatively well. It's gotten rather expensive in selected localities, but it affords a jurisdiction like Rappahannock to allow for a rezoning, but to accept proffers that are designed to mitigate the impact of that zoning that might be slightly different from what the current plan and zoning ordinance articulates for a particular tract of land. If we move on down a little bit further, because I think we're going to be able to, and I should have a watch with me and I don't, so I know we've got to be getting close to 6:50. Special exceptions, special use permits, or conditional use permits. What do y'all call them in Rappahannock County? You call them special exceptions?
We call them special exceptions or special use permits, two different categories.
Excellent. Okay. The terminology, special exception, conditional use, special use permit, that they're used interchangeably, although the Code of Virginia makes provisions for, as you see, special exceptions, 15.2.2201. But a great many Virginia county, cities, and towns refer to them as special use permits or CUPs, conditional use permits. This too is a common practice, and the difference compared to conditional zoning, you as a planning commission, staff, governing body can put the conditions on the granting of the special exception. Whereas under conditional zoning, the proffers that are attendant theoretically are to come from the applicant. Now, as you're probably aware, there are selected jurisdictions that have developed and drafted and adopted proffer policies. That's present in Prince William, that's present in Loudoun, that's present in a lot of different jurisdictions across our Commonwealth. And proffer guidelines are permissible under the Virginia statutes and in the eyes of the court system. Now, you got to be careful with the articulation of proffer guidelines. They must not carry with them the notion that it's contract. If I do this, then you'll quid pro quo, in other words. It gets very close. You have to be careful in how you draft your guidelines. They must be just that, guidelines, not absolute conditions that must be proffered. Then you're approaching contract zoning, which is not permissible in Virginia. And then she talks about variances, and she rounds out her handout with additional narrative that talks about building a defensible zoning ordinance, the yellow brick road approach, which I like her terminology, wherein she's suggesting, as we've already touched on, if you do the linking pin function, 2200 with 2223, or in zoning 2283 and 2284, then you're demonstrating the reasonableness of your actions relative to a zoning ordinance and the application of criteria to be satisfied in determining whether or not to permit a rezoning of property. If I want to rezone property in Rappahannock County, I have to fill out an application form. Now that application form in your instance is probably rather circumspect, and that's not meant to be disrespectful, but it is important that you can review your application within the context of 15.2.2284, because each of those criteria that are listed under 2284 are fair game. Whether you know it or not, they are fair game for you to reference and use in determining whether or not, as a planning commission, you would support the proposed rezoning, or as a governing body, you would find favor with granting a rezoning. Those same criteria can be used by you, should be used by you in denying a proposed rezoning. Thus, those criteria, if you're going to use them in a sense of fairness, they should be reflected on the rezoning application form. Now, that does result in a lengthier form. In a lot of rural jurisdictions, we don't have staff, we don't want to be overly bureaucratic or burdensome with our paperwork. But if you're going to use the criteria found, the 9 criteria listed under 2284, then that should be shared with an applicant, maybe in a cover letter indicating that a rezoning in Rappahannock County is permissible, but in order to qualify for a rezoning, you must satisfy for an application. And our application features a question or a series of questions, and those questions reflect the criteria that are featured in the 15.2.2284 section of the Virginia Code. If you develop an application in that manner and or make clear that those criteria will be featured in or considered in deliberating the question of rezoning parcel A from one use to another use, then you have brought that to the attention of the applicant. And then it's up to them to craft a narrative that provides evidence as to why said application should, from their point of view, be supported by you. We'll look at this in more detail when we consider Greg's material following the break. Again, her golden rule or her yellow brick road narrative leads us through the defensible zoning ordinance criteria and then further down in her handout where she introduces, if memory serves, her magic words in terms of a zoning action. I think I've got that, or she has that in there. Yeah, you got the proper policy. Okay, compliance. Okay, keep on going. Okay, then she's talking about vested rights, which Greg also talks about. And vesting used to be statutorily determined in Virginia. Now it's determined by benefit of use is now determined statutorily. Thus, you see internal here to the SAS law vesting something significant affirmative governmental act, or SAGA. SAGA is defined as one or more of at least 7 events that are taken, such as the acceptance of a proffer, specifying use of a property, rezoning of a specific use or density, the locality's issuance of a special use permit or special exception with conditions, the granting of a variance, the locality's approval of preliminary subdivision plat, et cetera. All of these are significant affirmative governmental actions, and those are critical in terms of determining whether or not vesting has occurred. We continue on down through that set of material from Sharon, non-conforming uses, updating the zoning map, procedural issues with zoning, adequate notice, etc., FOIA, which you're probably familiar with. And then here it is, her magic language. Whereas this, insert Rappahannock Planning Commission or Rappahannock Board of Supervisors finds public necessity, convenience, general welfare, or good zoning practice requires the enactment of this proposed ordinance or amendment. Now, therefore, we do hereby recommend the Planning Commission adopt the following ordinance. You can use the same narrative, whereas in order to find for the public necessity, convenience, general welfare, and good planning practice, I move that we not approve the proposed rezoning, or I move that we approve the proposed rezoning. Those are magic words in the estimation of our court system. Not all circuits operate in this manner. When it comes to the Supreme Court, these are pretty critical words, and the Supreme Court, because the Supreme Court has used them throughout its history, Virginia Supreme Court. Okay, let's, if it's appropriate, take about a 15-minute break. Would that be acceptable?
I think so. That we'll get back around 7:30.
Yes, we'll come back at 7:30. We'll pick up with Greg Kampner's material, and then we'll also look at the material that Gary shared with you earlier today that we use in terms of decision making with the Planning Commission and governing body. Okay, good. All right, so we'll pick up in 15 minutes.
Thank you.
Thank you, Mike.
All right, let's see if Dr. Chandler is back.
He's back.
Yes.
Excellent.
Okay, wonderful. We'll look through the Albemarle County Handbook, specifically looking at chapters 3, 4, 5, and 9. And that should still allow us time to review that final set of material that was sent to you earlier today. Some of this is, again, a very valuable resource, and it is somewhat repetitive in part, but that's by design in order to build on the material that preceded in the chapter in question. Chapter 3 looks at the objectives, purposes, and nature of zoning, and it is commensurate with materials that Sharon included in her material. So in other words, we've touched on some of these, the Declaration of Legislative Intent, for example, 2200, and then the purposes of zoning under 2283, of which there are 11 purposes listed. This is essential in terms of drafting a zoning ordinance or updating a zoning ordinance in terms of permissible standards or items to be regulated or addressed. Matters to be considered in applying a zoning ordinance, 2284. Again, these are essential because they provide the basis for your support for or your opposition to a proposed rezoning. So again, as before the break, if you're going to utilize the elements under 2284, the existing use and character of property, the comprehensive plan, suitability of property for various uses, trends of growth, change, current, future requirements, et cetera. All of these are central to whether or not a community will find it themselves supporting a rezoning or opposing a rezoning. If you, again, use those, then you'll find that you're in a very strong position because it provides you the evidence necessary for a court to determine that your actions are reasonable under the law. Reasonableness is a powerful construct. Any action that you take as a unit of local government at some point or another must be determined, its reasonableness must be determined. And that's critical in planning and zoning applications and land use applications specifically for zoning. Under page 3-4 in Greg's material, talks about the discretion that a local governing body has. In fact, that the governing body is the most advantageous position, 3-530. The local governing body is in the most advantageous position to determine the proper uses of land within its jurisdiction. Long articulated by the Virginia Supreme Court, as well as, remember, the Ambler Supreme Court ruling that a determination has to be made, a law.
We lost you.
He's updating this volume, talks about the link between economic development, good land use planning, link between planning, zoning, and tourism. And that, of course, is a key variable that's at play in your county. It's a spectacular community in terms of its natural beauty and setting. And of course, you're adjacent to the Skyline Drive and the entrance to that natural treasure and resource. Thus, the kind of land uses that are in proximity, anywhere in the county, but in proximity to special territories such as the Skyline Drive, should receive consideration through the zoning function. And the purposes of zoning are such that the environmental consideration, the aesthetics, if you will, are permissible. Now, an ordinance or an action to support or deny rezoning purely on the basis of aesthetics, you have to be careful. But aesthetics were sanctioned by the U.S. Supreme Court, Berman versus Parker, 1954, Washington, D.C. case. And Berman v. Parker is still holds force in the estimation of the U.S. Supreme Court. So it's permissible, as the justices suggested, Justice Douglas, that there's nothing wrong with a community that wants to be attractive, wants to be pretty, wants to have a pleasantness as a part of its character. Wants to be pleasing to the eye, wants to sustain its natural landscape. All of those have been articulated as reasons that are defensible from a substantive due process perspective in a zoning case. That's the long and short of it, if you will. And there are cases in addition to Berman v. Parker that can be cited. The zoning as a political function is also quite direct. In fact, this is narrative from Calvert County in Maryland, but the theory that zoning is a political act, the Supreme Court, state and federal, has said yes, it's purely a line drawing exercise. And it's political because elected officials, such as a board of supervisors, are charged with drawing that line. Now, do we draw lines as a Democrat or Republican? Don't know. Don't know that we want to go there, but you should have a rational basis for why you have drawn a line where you have drawn it. You should have a rational basis for why you support a proposed rezoning or why you're opposed to a rezoning. And you need to articulate that, verbalize it so it's part of the record. Now, some attorneys over the years, and many of them have modified, say that or suggested that the planning commission just keep its mouth shut, follow whatever the staff is recommending and don't talk very much because you can get in trouble. Well, yes, we can get in trouble when we talk, but it's better to err in terms of at least advancing a rationale for why, as a commission or as a governing body, you feel compelled to support a proposed rezoning, for example, or feel compelled to suggest why the proposed rezoning will not advance the generalized public health, safety, necessity, convenience of our citizens in Rappahannock County. It stands contrary or outside the content and the vision that we've articulated for Rappahannock County. It's contrary to the goals and objectives that we have articulated in our comprehensive plan. And you can use your plan in that light. I've been an expert witness in about 18 cases in Virginia. Several of them have ended up before the Virginia Supreme Court. And one of the more famous ones is the Wendy's Western Virginia versus Salem. It's in the narrative. I think we'll come across it shortly if we move on to chapters 4, 5, and then the comprehensive plan. Key point in terms of that particular case is that the comprehensive plan was used by the city of Salem as a justification for why it was opposed to the Wendy's rezoning. And I knew we'd lose at the circuit level, which we did because the judge was closed-minded. That happens on occasion, but I was reasonably confident we would be sustained at Supreme Court, and we were unanimously. And the Supreme Court used some of the language that we brought to its attention through the discourse and course of the trial. The Lerner case from Loudoun County is also quite instructive, as we said before the break. It's the first case that the Supreme Court recognized the principle of the timing and phasing of growth and development in relation to available infrastructure. In Loudoun County, at the intersection of Dulles Access Highway, Route 28, and Route 7, there is a rather substantial shopping center there today. Way back in 1978, the Dulles Management Area Land Use Plan, or chapter in the county's comprehensive plan, designated that area, which was on the land use map, zoned for, targeted for industrial development, but in the comprehensive plan, it was decided or defined as a area that would be supportive of a ideal location because of the road network for a shopping center. And the owners of the shopping center utilized the comprehensive plan language as a basis for their request to rezone the land to bring about the shopping center because it was zoned industrial. And the Board of Supervisors at the time in Loudoun County Planning Commission recommended approval. The Board of Supervisors denied it. And in denying it, they cited their comprehensive plan, the North Dulles Management Area, the Dulles Management Area Plan, which said that the shopping center should not be approved, sanctioned, or built unless and until there was a revenue stream and defined revenue captured that would be utilized to bring about the needed transportation, ingress and egress to and from the shopping center. And the timing of that development in relation to the revenue as well as a population threshold. The language, if I remember it correctly, that shopping center would not be given the green light until a surrounding population between 100,000 and 140,000 population within 10 miles of the proposed shopping center location was present or could be documented, then the shopping center would not be embraced as a advisable land use for that intersection. In other words, they wanted to make sure that there was going to be an adequate population such that the shopping center would stand a reasonably good chance of being successful. Linked to that, and that was from the Shopping Center Association of America. I don't know if it's still called that, but they were utilizing narrative and track records and proven performance, best management practices as captured by the Shopping Center Association of America, saying that, yes, if you have that level of population for that size shopping center, then you've got a 70 plus chance of that shopping center being successful. And a successful shopping center, according to the bean counters for Loudoun County, their finance department said, now remember, this is conditional zoning where you can accept proffers. If you want to move on, go on to chapter 4, that would be fine. Because that's really where we're talking out. The material from Ed McMahon is fantastic. Ed McMahon is a tremendous resource. I think he's still active in the world these days, but has done some great work in showing the value of tourism predicated on the attributes of a community, such as the Skyline Drive, such as the pastoral landscapes that you have in your community. And of course, other parts of the country come to mind in that regard. But continuing with the Lerner decision in Virginia, 1980, the county finance department, in concert with the information supplied by the Shopping Center Association, calculated that if the shopping center were developed and it was successful at a rate of 80% occupancy with the anticipated turnover and exchange of money for said purchased goods, services, restaurants, etc., that the county would generate enough money through the tax revenue that could be earmarked for the transportation enhancements necessary to ingress and egress off of 28 and specifically, and then Route 7. And that was the reason why the question that Loudoun County asked the owners of the applicants, is there a population of 100,000 to 140,000 within 10 miles of this development? And they said, we don't know and we don't care because that's not relevant. Your comprehensive plan says it should be a shopping center. I want to build a shopping center. What's the problem? Well, they turned them down, and the applicant appealed it, and it went to the Virginia Supreme Court. Most observers did not give the county much of a chance because from 1948 up until Lerner, 1980, most of the land use cases on the substance of the action taken by the locality that had been adjudicated by the Supreme Court, most of them involved Fairfax County, had been ruled against the county. The county didn't win. And so there was concern that, geez, is this going to withstand judicial review? Supreme Court said not only does it not withstand just judicial review, it very prudently, objectively, and from a financial perspective, articulated a very precise rationale for why the shopping center should not go in until that population threshold was satisfied. So the Supreme Court upheld the Loudoun County Board of Supervisors. That was a watershed ruling in Virginia planning and zoning history. And it's remained on the books, and it has been sustained by the court in subsequent similarly situated land use cases ever since, including Wendy's v. Salem, which we'll talk about in a little bit as we go through Chapter 4. The scope of the zoning power, this is under 2280, the Code of Virginia. And then, of course, it goes into some detail explaining about the physical reach of zoning, its territory, its airspace, et cetera. And we do have the authority through the zoning action to extend upward in terms of airspace. In fact, that was borrowed from the Penn Central Supreme Court ruling involving Penn Central Station in New York City. Therein, in saving Penn Central Station, the historic facade and structure, which the railroad wanted to tear down, it was articulated that the space should be preserved because the reach of zoning was not just on the surface, but it also air rights extending upwards. And the court found favor with that approach. Enabled subject matter for zoning on page 4-2. This talks about key sections that are linked to the comprehensive plan. And look at the enabled subject matter for zoning ordinance. Water protection, a variance, that's with a BZA, special use permits. Modifications, which was an attempt by the Supreme Court 10 years ago to provide localities or BZAs with relief from the strict application of the variance standard, a la the Cochran ruling from Fairfax County and the Pennington case from Virginia Beach, and then the case also from Pulaski County. So the General Assembly authorized the granting of modifications. But the problem with the modification is you still have to use the variance protocol under the variance standard 2309. So it doesn't really help. Modification enforcement, administration enforcement fees, all of these things are part of the zoning function. And now getting into the amending and repealing plans of development, PUDs, plan unit development, incentive or density bonus zoning, which is the old terminology in the Virginia Code, consensual downzoning. Typically, the downzoning is viewed as a negative. Downzoning is perfectly permissible as long as you do it the right way. Single-family dwelling to preserve open space, family transfers, airport safety zoning. Mountain Ridge construction. Do you all have that in Rappahannock County? I haven't looked at your zoning ordinance. Do you all have a provision in your zoning ordinance that addresses Mountain Ridge construction?
Tangentially, and it is referenced in the most recent comprehensive plan.
Okay, I thought I saw that there, Gary, but I guess now, and that's foundation, it should be there, but now that would be useful in crafting a mountainside or ridge protection zoning designation. Some jurisdictions in Virginia have that, and you've got some height in your ridges across your county, and protection of that view shed is one of the articulated rationales for your plan and your zoning ordinance. So this might be a consideration down the road. Adopting an overlay provision that would apply to Mountain Ridge construction. Again, there's several examples in Virginia that would be useful. Conditional zoning, affordable dwelling units, affordable dwelling housing. Affordable housing is a criteria under 2200. It's a tough one, but there's latitude available to you as well as other jurisdictions, preservation, historic sites, etc. Going on down. There's a lot that's contained in that area. Transfer of development rights, TDRs. This was a long time coming to Virginia. Virginia Beach, Loudoun County requested General Assembly sanction for special legislation. And they never got out of committee. But TDRs were made permissible in Virginia back in the Tim Kaine administration as governor. And they represent, they can be challenging, but they represent a way forward as a manner or means by which you can transfer development from one area of your county to another area, a receiving or sending area. This is a great way to take pressure off agricultural land. Although you in Rappahannock County have been a leader in the state in terms of your zoning as it applies to sustaining agriculture in terms of your minimum acreage requirements for residential use in an agriculturally zoned section of your county. Uses that must be allowed by right, meaning a special use permit is prohibited. 4-5, agriculture, silviculture, you cannot deny those uses or require special uses. Residential uses, no special use permits required. Manufactured housing, tents serving as temporary structures, cemeteries, daycare or allowing for the care of others, group homes. Most people are surprised to realize that group homes for up to 8 people are by right permitted in any residential district in any county. And it hasn't happened very often, but a facility for recovering alcoholics or people addicted to drugs, they are by right. You can't be denied or turned down. Family health care structures, wineries, breweries, limited distilleries, activities for agriculture and agritourism, all of those have grown increasingly popular. Helicopters, commercial fishermen and seafood buyers along the waterfront for our state are also uses that are not to be minimized. Chapter 5 looks at limitations, Dillon Rule and limitations on a locality's land use authority. As we established with Sharon Pandek's material, Virginia is a strict constructionist Dillon Rule state. That again simply means that for something to be permissible in the eyes of the Virginia Supreme Court, there must be expressed authority for that action, that right, that function. You've got to be able to point to something in black and white in the Virginia Constitution and or the Virginia Code. That's the safest way to preclude or avoid being characterized as acting outside the purview of the Dillon Rule. Of interest, when the Constitution was last amended and adopted in 1970, VACO as well as Virginia Municipal League were both asked whether or not the Dillon construct should be visited or revisited or reviewed by the Constitution, and they said no. Memory serves, you won't find the term Dillon Rule in the Constitution, nor do you find the term Dillon Rule or Dillon's Rule in the Code of Virginia. Dillon's Rule is operative as a principle of jurisprudence. The Dillon Rule was adopted by the Virginia Supreme Court in 1896 in the Redmond versus Winchester, Virginia case. They said, we will be guided by the premise as articulated by Justice John Forrest Dillon, that localities only have those rights that are expressly conferred or reasonably implied from a reading of the express power or declared essential to the needs of corporation. They quoted him with his permission in advancing and handling that case. Thus, the courts adopted the Dillon Rule. The Virginia General Assembly has not adopted the Dillon Rule, but has chosen to abide by the construct of the Dillon Rule. Whether or not the governing body is enabled is a part of the two-step process in Dillon Rule analysis. On 5-2, there are references to case law there that makes clear how one makes that determination. Step 2, on 5-3, if it is determined that the local governing body is unable to act as it did, whether it properly executed the power. That's important. You've got to not only have authority to act, but then you acted in a manner commensurate with the implied authority. And again, you look to the code relative for guidance in that regard. In some instances, the code does not provide guidance. For example, 15.2.22.80 identifies and says that the drafting and adopting of zoning is permissible in Virginia and identifies four general purposes. But it is silent with respect to how you actually effectuate those four purposes through the zoning function, through the line drawing exercise. As a result, the court is seen fit to defer to the locality and to drafting their zoning provisions and standards. And thus they look at the equity of that action. In other words, the same reasonableness that they apply in determining the validity of an action, that reasonableness also extends to the witnessing of the event through the zoning function. Subdivisions are enabled authority, as you're aware. You've got to have a subdivision ordinance. You have to have a comprehensive plan. Must you have zoning? Zoning mandatory across the state of Virginia. What do you think?
For earlier, the answer is no.
Yeah.
The answer is no. Zoning is only mandatory in selected states. It only became mandatory with the adoption of the Chesapeake Bay Act in 1998. The Chesapeake Bay Act governs all lands east of the fall line, which basically is the James River from Tidewater up to Richmond. And the fall line happens there. In other words, the bay and the ocean no longer cause for the rising of the tide, if you will. All lands east of the fall line, which basically is I-95 and 64 from Tidewater to Fairfax, all counties, cities, and towns east of that line in 1998 were mandated, if they didn't have a zoning ordinance, to prepare and adopt a zoning ordinance. The balance of Virginia, zoning is local option. Today, out of 95 counties, 87 have zoning. 8 that don't have zoning are all in Southwest Virginia, extreme Southwest Virginia, and 3 of the 8 counties are presently considering zoning. Every city has adopted zoning, and every town of consequence has adopted zoning. But zoning is not mandated in Virginia other than through the Bay Act. Capital improvement programs are not mandated, but they are strongly, strongly recommended. And in fact, if you want to engage in conditional zoning with proffers, you got to have a CIP. So in one sense, there's your mandate. If you're going to accept proffers, you have to have a demonstrable CIP that is crafted in the manner commensurate with 15.2.22.39 of the Virginia Code. And if you want to look at the timing and phasing of growth and development in relation to available infrastructure, you best have a capital improvement program. If we move to Chapter 9, looking at the comprehensive plan, this material, again, is somewhat akin to what you saw with Sharon's Pandax handout. One of the things that I like about with Greg in this particular volume of the handbook, which was, this chapter was written in 2018, he introduced the boxes as a way to draw the reader's attention to summary points, because as we can see, it's a lot of small words on the page and it's very lengthy. So where you see a box like there, what goes into developing a comprehensive plan? Well, he reviews some of the key points from the preceding paragraph. Descriptive matter that must be witnessed in developing the carefully crafted surveys and studies under 2223. And there you see some of the same language that's in 15.2.2200. May include the use of the land, the preservation of ag and forest, all attributes and characteristics, the condition of existing development, natural resources, dam break inundation zones, and other such matters. So you have that latitude in terms of what goes into developing the comprehensive plan. The content on the next page, as you see, talks about the long-range required content. You have to have a long-range recommendations for the general development of the territory covered by the comprehensive plan. It must also have a transportation element or plan. You must have road and transportation map, and you must address affordable housing. Those are the required plan content items. Now, and much as affordable housing is a good example, there's a requirement, but there's no real direction on how to satisfy for affordable housing. So what has occurred in most jurisdictions of the Commonwealth that have affordable housing standards is that they create a formula and they use that to satisfy for affordable housing. There's no state planning office in Virginia, no state planning police reviewing your document, as happens in other states, to determine whether or not your Rappahannock County Comprehensive Plan has narrative devoted to providing for affordable housing. Now, if a person were to bring a complaint, filing, objecting to the lack of affordable housing measures, the court is not going to rule against you. The court would, if felt moved, would suggest that you should address the affordable housing question in more specificity. The courts are not going to find your plan null and void because it lacks a required element, but it could create difficulty for you if you happen to find yourself on a circuit court that maybe does not view planning as a favorable exercise, or maybe is in a bad mood that day. Again, Greg goes into detail talking about the how to satisfy for the required content and then the optional content. And herein you have a lot of discretion. So even though we're a Dillon rule state, before I forget, what does Dillon rule say according to the Virginia Supreme Court? You can only do those things that are expressly authorized. My gosh, look at what you can do in developing your comprehensive plan. Some of them are required, but the great bulk of what goes into your county comprehensive plan is at your discretion. So no one amongst us would be surprised if they picked up the Williamsburg, Virginia comprehensive plan and you find a heavy emphasis on tourism and historic preservation. Don't think any of you would be surprised. No one would be surprised to review the Augusta County or the Rockingham County Comprehensive Plan or your county comprehensive plan and see the emphasis placed on the preservation, maintenance of agriculture and the rural heritage that is characteristic of your jurisdiction. Now, you might be surprised to pick up the Norfolk, Virginia Comprehensive Plan where I grew up and find a 20-page chapter on agriculture. I'd be shocked. There are only 2 farms in Norfolk, and one is owned by Virginia Tech as a demonstration farm. So we're not going to have a heavy emphasis on preservation of agriculture with only one farm. So the court, it talks about looking out for forestal and agricultural uses. The court knows that in some instances, that's not going to be a factor of consideration. As a result, it's not going to be emphasized. So when you look at the comprehensive plan, the consistency and factor, Greg has reference to some California statutes, but they are applicable to Virginia in that the Virginia Supreme Court has made clear that there should be internal consistency within a plan in order to satisfy for the equal protection clause of the 5th and 14th Amendments, as well as the Virginia Constitution. As a result, there has to be a narrative that makes clear to the reader that you're being consistent in establishing a policy. And if you deviate, as in the case of, go back to Euclid, they had their 6 residential zones, and internal to those that said no industrial use. So they had to craft an argument or a narrative that justified why residential should not be, or industrial uses should be permitted in a residential zone, which they did, and it satisfied for the Supreme Court, U.S. Supreme Court's inquiry. All right, if you look at the amending the comprehensive plan on page 9-5, there's reference here to some of the important cases, as well as Attorney General opinion, utilization of the comprehensive plan opposite proposed or existing community facilities or public utilities. All of those are important and are part of your what is now known as the 2232 review. So if a proposed rezoning comes to you and it has an impact, or you determine that its impact will be of consequence on the existing road network or infrastructure such as water or sewer, then it's appropriate that you ask the question to determine the level of impact and determine whether or not your systems can support that kind of enhanced utilization or enhanced traffic. Or are there needed road improvements in order for the development to not prove injurious to the safe movement of cars and goods and services? So if the road is inferior or some component of the road is inferior, then that could be a reason for not supporting the development at the intensity that is proposed. That also could give rise to the potential of proffers to mitigate said impacts or conditional use for approving a development or conditioning it on some improvements to the infrastructure. Let's see here. All right, the transportation planning, that VDOT must be play a role in that regard relative to reviewing proposed rezonings and the impact that the rezonings will have on the road network, much as you have to put in your plan anticipated road enhancements. You have to, with VDOT assistance, look at how much that is going to cost. The comprehensive plan, the role of the plan in legislative zoning decisions. We touched on that with Sharon's material and their key cases that Virginia Supreme Court has determined that play how the comprehensive plan serves as a guide for zoning decisions. The box that Greg has on page 9-8 is very important. He also shows through the narrative where the plan is not supportive of the zoning action or decision, or the plan is being viewed as supportive of the rezoning. And of course, the Lerner case, which you talked about, the board's decision to deny the landowner's rezoning application was predicated on his failure to satisfy for the minimum standards as articulated in the comprehensive plan. And that was that population threshold, which would in turn result in adequate revenues needed to make the transportation and related improvements to service that shopping center. Again, a very, very key case in that regard. Wendy's case on 9-9, herein Wendy's was a land development, or this parcel in question is adjacent to the General Electric plant, which was in Salem, Virginia. Salem, Virginia is a very relatively small independent city, shares a common boundary with Roanoke City, Roanoke County, but it has 8 industrial or commerce parks, which is a fair number of commerce industrial parks. Because it's a landlocked city and cannot annex, the City Planning Commission and City Council was very prudent in identifying commercial areas or industrial areas which would generate higher tax revenues versus residential uses. Adjacent to this area was an old neighborhood, but very attractive neighborhood, tree-lined, et cetera, et cetera. And the Wendy's wanted to put a Wendy's restaurant on a vacant corner adjacent to Route 419, which is a major thoroughfare connecting Salem to Roanoke City and Roanoke County. And on one corner was a bank, on one corner was a Hardee's, and on the other corner was a Pep Boys auto repair or auto parts store. And Wendy's wanted to put it in as a commercial use, but the property was zoned industrial, as was the adjacent neighborhood. Although zoned industrial, it had been developed as a residential use. And we argued that it should be denied because the intent of the city plan was that the area, including that neighborhood with those existing homes, one day would be transitioned into the city's final industrial park. Circuit Court found in favor of Wendy's because we turned them down. Supreme Court of Virginia sustained the city's action because the comprehensive plan was a reasonable guide in looking at the commercial use being superior, industrial use being superior, and the existing neighborhood, which Wendy's argued was inappropriate, was in fact viable as a community. And as a result, the court found favor, which involved the fairly debatable principle again. Timing and phasing part of and then balance of this handout is similar to the earlier pieces that look at relating the planning and zoning to economic development and tourism. If we look at, because I know we're up against the clock, but if we quick look at the material that was shared with you earlier today, looking at PC or Planning Commission decisions, points to ponder. This is a component of our closing session that focuses on deliberation and decision making. Here reviews some of what we've already touched on and you're probably familiar with. The Planning Commission, this is 15.2 of the Virginia Code 2210, talks about the size and appointment of a commission, et cetera. If you look at constitutional principles of note, 5th and 14th Amendments, Article 1, Section 2, Virginia Constitution, procedural due process. This is where we get in trouble if we screw up. Substantive due process requires that a regulation or action not be arbitrary or capricious. Land use regulations actions must advance a legitimate public interest. Legislative acts are defined, ministerial acts are different. They are not viewed as legislative acts because the facts have been and predetermined policies are in place. In other words, a subdivision ordinance, if I'm developing a subdivision, as soon as I meet by right, the plan calls for a subdivision, zone for subdivision, then I'm entitled to a building permit as soon as I satisfy for the subdivision requirements as determined by your application building permit that Michelle and or Gary would grant me in Rappahannock County. As soon as I meet all those criteria, then you have to give me a building permit and I get to build my subdivision. You can't turn a subdivision down, a proposed subdivision, because of lack of infrastructure. The court has found disfavor with that because they say that's misplaced planning. You should not zone it for residential use if you don't have the adequate infrastructure. So the court presupposes that you've done your due diligence when you draft a subdivision ordinance. Thus, there's no wiggle room, if you will. If you continue on down through the material, Gary, just a quick reference to what is presented here. Keep on going. I don't have it in front of me here. The legislative act, planning commission does not act in a lawmaking capacity. It is permitted to consider the same matters that are legislative in nature that you will make as a governing body with a rezoning request. They're going to review the same material. That's fine. The same factors that should be part of your review once you get it as a governing body. All right, keep on going. Presumed to be valid. Keep on going. Text and amendments. Go on past that. Let's go to towards the end. I think, Gary, there's some material there that looks at land use decision making. We can come to that. And any of you as board members review this, you have questions you want to ask me later, feel free right here. Feel free to do so. I'll respond to you by phone or by email. Public hearing considerations affecting decision making. This is the procedural due process. Notice must be timely. Hearing must be procedurally fair. Petitioner must be given a reasonable amount of time to present their case. Opponents should be given a reasonable amount of time to present their case. Time limits, if possible, should be imposed on each side and not on each side as opposed to each person. But most of us use the 3 or 5 minute rule. That rule should be part of your bylaws for your planning commission. If it's not written down, then it should be written down in a statement of bylaws, and the chair should abide by that. If you want the discretion of the chair to have the discretion to suspend the rules, that's possible. That too should be in the bylaws for either the governing body or the planning commission. If you continue on down, Gary, again, there's reference. A person who's denied due process can bring suit for damages under the 1983 provision of the 1871 Civil Rights Act and as amended with 1964. Our due process and decision making. Land use law is complicated, but in part it's not. It's somewhat simplified. If you'll test your actions for basic fairness, you'll avoid most legal problems. This is part of both procedural and substantive due process. Did everyone who is likely to be affected by a decision, did they know there was going to be a hearing? Did all sides have a chance to talk about it? If the proposal was denied, will the landowner have an assortment of land uses left, even if it's not the one he wants? If someone reads this transcript of your meeting a year later, will they be able to understand from that information alone what you did and why? Is the commission's actions, recommendations consistent with your adopted plan or plans? Is there a reasonable connection between conditions included in your action and the problems that they're supposed to address? Continue on down, Gary. I think the next one looks at common sense checklist. Legitimate public interest. Okay, first and foremost, your zoning action must advance a legitimate public interest. You've got to be able to articulate that public interest. Is the regulation a reasonable way to accomplish the public interest? The regulatory action, the regulatory approach should be reasonable in balancing the public interest opposite the private interest. That's been evident from the very first Supreme Court, U.S. Supreme Court case, Euclid v. Ambler. Is a regulatory body should be able to show how their actions will advance the public purpose. Can the relationship between the regulation and the public interest be documented? You should do that first in your comprehensive plan, through the narrative in your plan, and then through the zoning ordinance in your statement of intent and the purpose of said district, R1, R2, what have you. Will the regulation allow reasonable economic use of the property? Again, the public interest being served by the regulation must be balanced with private interest such that there's some reasonable use of the property possible, assuming certain zoning standards are present. As long as there's a reasonable use remaining following your zoning action, then, and that's reasonableness on its face, is balanced and is judged by the court to be fair, then no taking has occurred, if that taking is the question, down zoning, for example. Or if I have a parcel that says I can develop 4 units an acre, but I want to rezone it so I can do 8 units an acre, and you turn me down. I might claim that you acted arbitrarily, but the court's going to remind me you still have a by right use to develop 4 parcels or 4 houses on the tract of land that you own. So what's unreasonable there? Now, the reasonableness balanced opposite economic costs is a variable, but the court's not concerned with that singularly. Okay, is the regulation fairly applied? Generally similarly situated properties are treated in a similar fashion. And then elements of defensible procedure. Again, the notice, opportunity to be heard, full disclosure, findings. This is important in terms of your legal footprints. Now, your attorney may have a different view, but herein, there should be some articulated reason for why a person is motioned to approve a rezoning or made a motion to deny a rezoning. And the chair should go around the dais, give everyone a chance to comment. And in some instances, chairs, nothing wrong with doing so, call on a board member who hadn't said anything. Supervisor Smith or Jones, we haven't heard from you. Anything you might care to add? You've given him or her the floor and given him or her an opportunity to share their points of view. Thus, the record has some narrative attached there too. The Supreme Court of Virginia does not like receiving records that are void of any narrative. They get very angry with that. Findings are legal footprints. You got to have those. Okay, if you continue on down, I think there's one more that, a couple more there, but the next one I think is another segment here, if I remember correctly. No, there isn't, I'm sorry. So back up, let's go back up the page to number 6, timely, unbiased decisions. Timely decisions. The decision maker, the decision should be made within a reasonable time construct. Once a planning commission acts on a proposed rezoning, then the governing body can take up to 12 months to act on that planning commission proposal. But if you're going to take up to 12 months, then you should be utilizing that time in a fashion, in a manner that is not going to be judged to be foot dragging. Having complete records, clear rules for proceedings are terribly important, not only for procedural, but also substantive due process. And then I think the next 2, which will wind it up here, or next one, the bottom line, and this is from the Virginia Supreme Court. A court, meaning the Supreme Court, is based on their actions, will be reluctant to overturn a decision made by a governing body that, one, is well-reasoned, two, supported by valid planning analysis, three, allows for some reasonable use of the property, and four, was fairly made. You touch those four bases, like you touch first base, second base, third base, and you touch home plate, you've scored a run. You touch those four bases, you assure for those four bases, then your actions from a substantive due process point of view will not be overturned by the court. And these criteria ought to be not only utilized to help you if you have to go to court, God forbid, but it should also help you make a good judgment or arrive at a judgment that is in the community's interest because it's been predicated on your county comprehensive plan, its goals, objectives, its vision, as well as your zoning ordinance as a means to effectuate the comprehensive plan. I know we've covered a lot in a really short period of time, and there's ample additional information. Chapter 10 in particular in Greg's handout or handbook talks about, again, some of the criteria as applied in court proceedings. But the takeaway in terms of our time together this evening is that your actions, if they are reasonable on their face, and if you have done the necessary groundwork and articulation of a record, crafting of a narrative, the expression of a rationale guiding your action, then your action as a member of the governing body opposite a proposed rezoning, either in favor of it or opposed to it, will withstand the scrutiny of the court if you have to go to court. And sometimes we have to go to court in order to win, if you will, in order to advance the premise that's captured in your comprehensive plan and your zoning ordinance. And to the credit of the Commonwealth of Virginia, the Virginia Code has evolved since its inception in terms of 15.2/2200 back in 1926, updated in 1962, and then subsequently amended many times up to and including the present calendar year. If you follow the code and then you abide by the procedural due process requirements of the federal and state constitution, then you're going to be well positioned to provide the stability and direction that your county has crafted for itself in the form of the county comprehensive plan. Be happy to answer any questions you may have, either now or you can send them to me and I'll respond to you at the best of my ability through email or otherwise. And I hope this has been of some assistance to you as you consider the very important planning and zoning function from your perspective as a duly elected member of the County Board of Supervisors. You have a very important job, but you could do it, and you have ample guidance in the code of the Commonwealth of Virginia. And as I said early on, although we're a Dillon rule state, when you look at the term shall, whenever you see the term shall in the Code of Virginia, that's must do. Term may, you have the discretion. There are a lot of mays in the Code of Virginia when it comes to planning and zoning. And that satisfies for the expressed power to develop, for example, Mountain Ridge Overlay District, if that's something you think would be valuable for Rappahannock County as you move forward. So, be we a Dillon rule state, it in no way is of a confiscatory nature when it comes to planning and zoning. We have tremendous latitude. You have tremendous latitude as a governing body on behalf of your citizens. And I wish you well in your endeavors when it comes to planning and zoning. And thank you for your time.
Thank you so much, Dr. Chandler. I do believe we have some questions.
Okay.
Many. And then I thank you very much for allowing us to also send you emails or give you a call because I'm sure there are other questions out there.
That'd be wonderful. Or you can gather them up and send them to me en masse, and we'll.
Right, Mr. Parrish, I think.
Well, I just got two really short questions. This is Chris Parrish. The 15-2230 says comprehensive plan must be reviewed every 5 years. There's nowhere that says we have to make any changes, is it? We could just review it and leave it just like it is.
What I wrote down was if not needed to change, you still have the public hearing, share it so that everybody sees it, and then you can change the date. You don't actually have to make any actual changes.
That's what I was thinking. The other thing is, I took a class from you down in Richmond a few years ago, and you stated that there's not a single law in Virginia that says that we're required to follow that backs up the comprehensive plan. Something to that effect. Is that still your position? I quoted that a couple of times, and I was accused of blasphemy.
Okay. I caught the first. I didn't catch the first part. Come again with that, please.
I think your statement was there's not a single law in Virginia that requires us to follow the comprehensive plan.
Oh, well, there's not an explicit statement in the Code of Virginia that says you must implement the comprehensive plan. It's implied, it's inferred, it's logical that if the state mandates that you have a plan, that you would want to follow the plan. But that's correct. There's no law in Virginia that says you must implement the comprehensive plan. Okay. Just as there's no law in Virginia that says you must rezone property.
Right. Okay. Thanks a lot.
Yes.
Any other board members?
Mike, it's Kier Whitson. And
yes, yeah.
I think we'll be well prepared for our new class starting Friday, so that's good.
Yeah.
We'll look like teachers' pets, kind of.
Good.
Friday. I had a question about Almond, the Almond decision.
Yeah.
And reading that and the rest in development and everything else, I'm thinking about, as you know, we have this rezoning application before us, which is partially the impetus for us hearing from you tonight. Yeah. It sounds like in Almond, basically the court ruled against the county because Almond was singled out, it seems, vis-a-vis other property owners in a similar position. And maybe it's an incorrect construct, but I'm thinking about our comprehensive plan that says development in and around the villages in the town of Washington, and we have a rezoning application that's in and around the village of Sperryville. And my concern in thinking and reading a little bit tonight about Almond is that if we said yes to that rezoning application in the context of the Almond decision, doesn't that then mean we would be compelled to say yes to a similar rezoning application in the spirit of the same provision of our comprehensive plan near another village? Or if we said no, would it not put us in a position where we would also have to say no to someone else in the same position?
Yeah. Yes, I appreciate your line of inquiry and your thought process, your linking pin thought process. But the Virginia Supreme Court has also articulated post-Almond that each case is to be decided on its own merits. And the Supreme Court of Virginia has time honored that declaratory statement and judgment. Each case is to be decided on its individual merits. We do hear a lot sometimes that whether we rezone property, then we'll say, oh, that's a precedent. How do we turn down the next application?
We're hearing that a lot.
Yes. No, you don't. It's a consideration, no question. Almond has a number of variables that are at play here. We also have to appreciate where the Virginia Supreme Court was back in the late 60s and into the early 70s. The Snell case is from Fairfax County in '74 is particularly instructive because, and I'm going to butcher it, but the generalized statement I'm trying to recall from memory was that the Virginia landowner must be cognizant of the fact that there's no security in zoning. That wasn't the term. We can't assume that once zoned, always going to be zoned that way. There are no expectations relative to zoning, and zoning can change and must change and will change based on conditions. As a result, the landowner should not expect that there would be implied stability with a zoning ordinance or action. But the Virginia landowner can be assured by this court, Supreme Court, that any actions to design that change the ordinance will only be taken as a byproduct of study, detailed study, analysis, and review.
Yeah.
In part, that's where your review comes into play when there's a rezoning before you. You get to revisit your zoning ordinance as well as your comprehensive plan. We don't want to talk about the case that's going to be before you, but there are some elements there that one would be able to, I think, with justification, find favor with. Yes, we should encourage growth and development and proximity to the villages and the town of Washington.
Right.
That's kind of what our plan calls for. That's fine. But it's at your discretion as to whether or not you want to do that specifically based on the conditions that are at play with a specific application in front of you. Okay. Yeah. There may be mitigating factors that involve transportation, water lines, sewer lines, access across streams, those kinds of things. Okay. And so you are subject to that, but at the same time, there is considerable latitude, including the fact that, as was pointed out by Gary, there's nothing that compels you to follow your plan. Although you'd be wise to follow your plan, nothing that compels you to follow your plan. Okay. Don't know if that helps or not.
Yeah, it does.
I'll look at it all in a little more detail. Okay.
No, that's fine. And Mr. Curry, if someone has a Lexus account, I'd love a copy of Allman or
Mr. Goff can get that for you.
All right.
Yes.
Dr. Chandler, one thing you said, I think early on in one of the classes I was taking was that we being Rappahannock County, may not be allowing as much growth as other surrounding counties may want us to. Yes. Is there any pressure to a county to change things to allow larger growth, or are we totally in control of that and we don't have to worry about everybody else?
Yeah, you're fundamentally in control of that, but one of the provisos that are now mandatory content of a comprehensive plan looks at the provision for affordable housing, not only based on the need in Rappahannock County, but also considering the needs of the planning district in which you're located. And so that introduces a proposition that typically we haven't thought about, meaning that we've got to look at, well, what are the needs of, you're in the Rappahannock, Rapidan PDC, if memory serves. So, and you're adjacent to Culpeper, Fauquier, and I guess Madison. And so comprehensively, the four jurisdictions should be thinking about, well, how much growth is the PDC going to experience over the next 5 to 10 years? And then, as occurred in Loudoun County under their Affordable Dwelling Unit Commission and Committee back in the late 90s and into the early 2000s, they looked at what Loudoun's fair share would be of the Metro or Northern Virginia PDC and Metro Washington growth. And in making provisions for affordable housing, they considered that straight up in the 1991 comprehensive plan for the county. And I think in subsequent additions, they've continued with that. So, Clark County to your north has a zoning ordinance that is a little different. They use sliding scale, and they also have a very strict historically public infrastructure policy. no water and sewer be outside the Berryville service area. Berryville is the county seat, and they've drawn a line around Berryville. Berryville has drawn the line that's in Clark County with Clark County's concurrence. And they're indicating that beyond that line, no water and sewer line will be extended or introduced, nor will there be major enhancements to the road network outside of the existing Route 7 and I guess 522 comes up that way. So as a result, Clark County is not likely to experience a great deal of growth. And some people say, well, you look at the population gain, Loudoun County is, doubling its population every 20 years. And then you go over to Frederick County, they've got a lot of growth. Clark County's grown, but not as rapidly as Loudoun and Frederick. Now, some people say that's not fair. Well, who's to say that's not fair? If the goals of Clark County are to have a agricultural, rural heritage-based natural environment and economic base, and they don't want to put themselves under a heavy tax obligation by having expensive infrastructure projects. The fact that they have designed their plan and ordinance to achieve that outcome, who's to say that's not satisfying for 15.2/2200, where you're, looking at making sure development is consonant with the efficient and economical use of public funds. And as a goal, we want to have a livable community. We don't want an exorbitant tax rate or tax obligation. That's fair game in my view. And I think the Supreme Court agrees when you look at the Lerner ruling and the fact that 15.2/2200 says growth shall be consonant with the efficient and economical use of public funds. So I think if you want to limit growth based upon the land's natural carrying capacity, no heavy infrastructure being introduced, and not an overt, overly burdensome tax liability. So you plan and then zone to the plan, allowing for some growth, but not exponential growth. That's at your discretion until the Supreme Court says otherwise.
Thank you very much. Any other questions from the board?
I'll follow up via email.
Yep. All right. Again, thank you so much, Dr. Chandler. And some of us will hear you on Friday, I believe.
Yes, that'll be wonderful. Yes, we get together, I think, at 10 o'clock. And did your binder show up yet?
Yep, mine did.
I think mine did. I haven't been to the post office yet.
Okay, I think Carrie sent one of the textbooks. The other textbook is on order and hopefully will be in by the time we convene on Friday. We'll look at some of this material, but actually our focus is going to be a little bit different. And, I hope you will find the course valuable. I think you will. I hope you will.
Yep.
And we'll see you guys on Friday.
Thank you.
Motion to adjourn.
Have a motion
again,
to
Mike.
adjourn.
Thank you.
Thanks so much, Dr.
Who is my second?
Who was the second? Me. Okay. Whitson and Smith. All those in favor say aye.
Aye. Thank you.
Okay, we can adjourn.
Thank you very much, Mike.
Good job, guys. Good job. Thank you.